Welcome to This Explainer. Today, we're diving into a seriously high-stakes legal battle that ends in a pretty surprising technical reset over at the Constitutional Court of South Africa. We're going to be unpacking the case of the National Director of Public Prosecutions versus Mohamed. And it is a fascinating look at what exactly happens when a government's incredibly aggressive fight against organized crime collides head-on with the rigid procedural rules of the Constitution. And, spoiler alert here, as you'll see, it's not just the lawyers who make mistakes in this story. The judges do too. Okay, let's just cut right to the chase and ask the core question that sparks this entire legal saga. How on earth do you strip criminals of their wealth if you don't even have a conviction? It's a massive question, right? It's all about the delicate balance between government power and our individual rights. See, when dealing with complex, organized crime, the state often struggles to actually get a criminal conviction. So they created a legal workaround to basically just take the money anyway. But the big question is, can they legally do that without stepping all over a person's fair trial rights? To make sense of this whole constitutional puzzle, here is our roadmap for today. 1. Fighting organized crime. 2. Forfeiture without conviction. 3. The High Court's ruling. 4. The wrong constitutional remedy. And finally, 5. Back to square one. All right, let's get into part 1, Fighting Organized Crime and the Prevention of Organized Crime Act. Let's start by looking at the massive threat that prompted the South African government to create such aggressive legal tools in the absolute first place. Basically, conventional criminal penalties simply weren't deterring these crime bosses anymore. There was a rapid growth of organized crime and money laundering, and it was presenting a huge danger to public order. But here was the biggest problem. The real crime leaders remained completely insulated. They made sure they were far, far removed from any of the overt criminal activity happening out on the streets. So they get to keep all their considerable gains, even if their low-level operators happen to get caught. The state realized pretty quickly that they needed to remove the financial incentive for crime entirely. Which brings us to part 2, Forfeiture without conviction, specifically focusing on Chapter 6 of the Act. Now, this is where it gets really interesting. Look at the stark contrast in legal strategy here. Chapter 5 of the Act is your standard traditional approach. It's conviction-based. You go after the wrongdoer, you get a conviction, and then you confiscate their benefits. Simple enough. But Chapter 6, that is a completely different beast. It is not conviction-based at all. It focuses strictly on the property itself, meaning it can be invoked even if there is absolutely zero prosecution happening. Actually, scratch that, it's more than just a different beast. It's incredibly aggressive. Under Chapter 6, the guilt or the wrongdoing of the person who actually owns the property isn't even the primary focus. The state is legally targeting the property directly. They're arguing that the real estate or the money itself was used to commit an offense or is the direct proceeds of unlawful activities. They go straight for the assets, regardless of who is holding the keys. And there is a strict, aggressive ticking clock attached to this whole process. It's a 2-stage procedure to seize these assets. Step 1, under Section 38, the National Director gets a preservation order to freeze the property. Step 2, they publish a formal notice. And Step 3, they have a very strict 90-day window to officially apply to have that property forfeited to the state permanently. It is a completely rigid deadline, guys. If they miss that brief window by even a little bit, the preservation order lapses and the property has to be released. Let's move on to part 3, the High Court's ruling, and a major clash with fair trial rights. Okay, to really understand why the High Court had such a massive problem with Section 38, we first need to talk about the legal term ex parte. See, the state was securing these properties in secret. They were applying to the court and freezing assets without giving any prior warning or notice to the owners whatsoever. And this is exactly what happened to the trust properties of the Mohamed family. Now, the state's logic here is totally obvious, right? If you warn a criminal you're coming for their money, well, the money disappears. But from a strict constitutional standpoint, this is a very serious infringement on a person's right to a fair hearing. The High Court basically said, wait a minute, you're missing a crucial safety valve here. And in legal terms, that safety valve is known as a rule nisi. Think of this as the way the law really should have been written to balance the scales. It's essentially an interim order that says to the property owner, hey, your property is temporarily frozen, but you have a date to come down to court and show us exactly why this order shouldn't be made permanent. Because Section 38 didn't explicitly include this protective mechanism, the High Court felt property owners were literally being stripped of their constitutional rights to a fair public hearing. So because that safety net was missing, the High Court dropped a complete bombshell. They declared Section 38 constitutionally invalid.
They ruled that because the law forced the state to apply secretly in every single case without providing that rule nisi provision, it flat out violated Section 34 of the Constitution, which is the right to a fair hearing. As a result of this, they struck down that part of the law and officially invalidated the state's preservation order against the Mohamed family's properties.
That takes us to part 4, the wrong constitutional remedy, or what happens when you use a flawed judicial toolbox. Now, here is the massive twist in our story. When the national director appealed this defeat all the way up to the Constitutional Court, the higher court looked at it and realized the high court had completely botched the solution. Think of constitutional remedies like a judge's toolbox. When a law is deemed unconstitutional, a judge has different tools they can use to fix it. The high court used a hammer known as notional severance, which is where you try to surgically cut out the bad, offensive parts of a law. But the Constitutional Court pointed out a pretty glaring, fatal flaw in this logic. The problem with Section 38 wasn't what was actually in the law. It was what was missing from the law, that rule nisi provision. And you simply can't cut out an omission. The High Court desperately needed a scalpel, known as reading in, which is a tool where a court essentially adds the missing words into the statute to cure the invalidation and save the law. The Constitutional Court was pretty blunt about this. They firmly pointed out that the High Court's order was, in their own words, legally incompetent. Judge Ackerman noted that an omission cannot, notionally, be cured by severance. Which makes total sense, right? You literally cannot sever or cut out words that aren't there in the first place. If the High Court had just used the right tool, reading the missing protection right into the law, the state's ability to freeze those assets might have actually been saved.
And we need to zoom out for a second here, because in high-stakes law, missing the big picture is a fatal error. The Constitutional Court rebuked the lower court for a much, much bigger mistake. See, the Mohamed family hadn't just attacked Section 38. They had actually launched a massive, sweeping constitutional attack on the entirety of Chapter 6, arguing that the whole concept of civil forfeiture was unconstitutional. But the High Court, they got major tunnel vision. They ignored the wider puzzle and chose to hyper-focus on just one tiny procedural rule regarding how the application was filed.
Which lands us squarely at Part 5, back to square one, featuring a pretty sharp rebuke from the Constitutional Court. Judge Ackerman laid down a really strict procedural rule for the courts themselves. He stated that courts cannot just offer partial relief if it leaves the main dispute entirely unresolved. Basically, judges can't just take a shortcut. The High Court tried to take the easy way out by ruling on a narrow procedural issue, but in doing so, they left the absolute most massive, glaring question about the constitutionality of the entire forfeiture law completely unanswered. So, what did the Constitutional Court do? They flat out refused to rule on that narrow issue in isolation. Instead, they hit the giant reset button. They set aside the High Court's order entirely and sent the whole messy dispute right back to the High Court. They essentially ordered them to do their jobs properly, to adjudicate the substantive challenge to the entirety of Chapter 6 completely from scratch. So we are left with this fantastic cliffhanger. We've seen how procedural errors by both the state and the judiciary can completely derail a high-stakes case. But the core question, that remains totally unanswered. As this case goes back down to the High Court, we really have to wonder, how will the courts ultimately balance the government's desperate, aggressive fight against organized crime with the rigid, unyielding demands of the Constitution? It's a very delicate tightrope, and the final verdict on seizing assets without a conviction is clearly still waiting to be written. Thanks so much for joining me on this explainer. I really hope this helped clear up the anatomy of this incredibly complex legal misfire.